So this is the panel, challenges by the courts examining compulsory arbitration to class certification from the perspective of the practitioner. And this is kind of the panel where we wanted to have people talk about what's really happening in the trenches. So what we have here are practitioners, and I should also say dear friends of mine. Cyrus Mehri is one of the nation's preeminent plaintiff civil rights lawyers. He was the lead counsel along with the Bondurant firm in the Coca-Cola discrimination case, which settled for about $180 or $90 million, and did the
we stopped counting after a while.
Stopped counting. And the Texaco case. But the thing that I find most admirable about Cyrus is he doesn't look at these cases as wars against a company, and doesn't look at it as an opportunity to take a company down. He looks at it as an opportunity to make a corporation better. And I think he takes great pride in where Coke and Texaco have come because of his activities, and also the efforts of, we have the privilege of having Barry Ellen Roberts in the audience, and you'll hear from her later. She was the lead plaintiff in the Texaco discrimination case, Barry Ellen Roberts. Pat Szymanski, former general counsel to the Teamsters Union, led that union through a series of changes. Now he is the general counsel to the Change to Win Labor Coalition, one of the largest coalitions of labor unions in the country. Been a labor lawyer representing labor unions and employees for a number of years. Leslie Prohl is the director of the NAACP Legal Defense Fund in Washington, D.C. She was a civil rights lawyer in Alabama, so she too has been in the trenches, and she's got some perspectives not only on what's going on in the courts, but what's going on with regard to national policy and how we fill judicial appointments. My dear friend Bob Strope, who said he would not come unless he had his loyal opposition, Andy Kramer from Jones Day, with him, is the former general counsel to the United Mine Workers and a close advisor to AFL-CIO President Rich Trumka. And Andy Kramer, who we have the privilege of having with us, is a senior labor partner at the Jones Day law firm, but he is the chief outside labor counsel to the Goodyear Tire and Rubber Company and the chief outside labor and employment counsel to General Motors. So we have a terrific panel, and I want to get it started by talking about this question of arbitration. You know, yesterday, for those of you who heard Mr. Doar, John Doar, he talked about the power of the federal courts in addressing discrimination. We've heard a lot about the federal courts. We passed discrimination laws in the 1960s, which gave additional rights to go to the courts. In 1974, there was a case called Alexander Gardner Denver, which raised the question of what happens if you have an employment dispute. And there's a labor agreement, and the labor agreement requires the dispute to be arbitrated. The Supreme Court said, no, 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 very important, employees should have right of access to the courts. The question was revisited in 1991 in a case called Gilmer. Facts were a little bit different. There was no labor union, it was just an individual employment contract. Court said, no, this is different, we will compel arbitration. We get to within the last year and a half, and we have another case called Pyatt. Now it's back to the union question, age discrimination case arising from janitors in New York City. There's a labor agreement, and the labor agreement contains an arbitration clause. And everybody thought this issue was resolved. In fact, the Supreme Court says no, and they subtly distinguish Alexander Gardner Denver, and they say, nope, this issue has to be arbitrated, even though in this particular situation, the union wouldn't want to arbitrate it. Justice Thomas said, well, that's a problem. You can always sue the union for breach of the duty of fair representation. So, you know, when Mr. Doar talked last night, we were talking about the role of the federal courts, and now we're seeing this move towards addressing some of these problems through arbitration. And I want to throw it out, I guess, first to Cyrus and maybe then to Andy Kramer. Is this a good thing or a bad thing?
Mandatory arbitration?
Yes.
Well, it's a controversial thing, I'll say that. The whole idea of mandatory arbitration is very well explained if you look at Justice Stevens' various opinions over the years and dissents, which is that it's a good thing, actually, you could argue, if you have people of equal bargaining power who have decided, let's say two big companies, that they'd rather have their dispute in private arbitration than federal court. Where it becomes a controversial thing and really undermines exactly what John Doerr was saying last night about the importance of the courts, is when it's an unequal bargaining power and there are people who have their rights essentially squashed. As the prior panel talked about the juxtaposition of procedure actually being substantive, when you take away someone's rights by putting them into arbitration, then I think it's very controversial. Do you want me to talk about some of the recent Supreme Court cases, Ruben, Stolt-Nielsen and the Concepcion case? Last year, the Supreme Court took on a case called Stolt-Nielsen, which was in the antitrust context, and the arbitration agreement said all disputes would go into arbitration. And it didn't say one word whether or not that included class actions or didn't include class actions. And the arbitrators, which was a panel of 3 world-renowned people, including Ken Feinberg, said, well, it includes class actions. That's included with all disputes. And the Second Circuit ultimately agreed with that. But the Supreme Court said silence is golden, so to speak, for the corporation or the defendants, who, by the way, some of them were facing criminal prosecutions and things like that as well. But that this was silence means that you don't have the right to a class action, because unless the parties explicitly put that in, then you don't have that. So that's silent banned on class actions. Now the issue is, what corporation is going to put out there an arbitration agreement in a one-sided negotiation, for example, for consumers or employees, that's going to explicitly put in the right to class actions? That's never going to happen. And the problem with the Stolt-Nielsen case is that it's already having an enormous impact on cases, including cases in my office. We have a case of labor violations where workers are being paid below minimum wage when you total it all up, and we're moving along to prosecute that case and moved into arbitration. We're fine. We'll bring a class action there and get notice out to the class. But the arbitrators said, well, the agreement is silent, and silence is golden for the big corporations, so that means you don't have that right. And so what we're facing is, when our clients were in federal court, they had that right to get the notice out of the labor violations to their coworkers, and they go to arbitration. That right is now vanished. Arguably now that's vanished. And that's exactly the concern that Justice Ginsburg brought up in the oral argument last year. How could it be that you have this tool, statute, that Congress gives you this tool, and then it just disappears when you walk into arbitration? So that issue now is already had a negative impact, the Stolt-Nielsen case. What is really at stake this term, and Josh, who's on the prior panel, wrote an amicus brief, and others have, to try to preserve people's rights, is this case called Concepcion versus AT&T. And there they have an outright ban on class actions that the state of California, and this is just your standard credit bill that you would get to buy a cell phone, the standard contract has that California says if it has an outright ban on class actions, that's unconscionable, because that does affect the statutory consumer protection laws that the state of California has, and they want it to be vindicated, and they want to bring that to life, to have a deterrent effect. So right now, hanging in the balance is this case, and if it comes out in favor of AT&T, I think you'll see even more use of mandatory arbitration clauses, that it will accelerate that, so more and more employees will have given up their civil rights the day they even applied for a job, the ability to vindicate that in a systemic way. Because class actions are the tool that's out there to bring about systemic change, like Barry Ellen Roberts, who's here today, was able to do in the Texaco case. She couldn't do that systemic change if she was in arbitration. And no one would know about the case if it was in arbitration. No one would know about the Texaco tapes where we had the senior executives destroying evidence and making pejorative statements against African Americans and people of Jewish descent. No one would know about that. So that is what's at stake right now in the Supreme Court, and it's hard to know what the outcome is. I know that there were some comments that were encouraging, including from Justice Scalia, who seemed to be concerned about the Supreme Court stepping on states and their own interpretations of their own laws. So maybe it will come out better than Stolt-Nielsen did last year. But there's a lot at stake. But even if the consumers in that case win, and there is the ability of states to hold class action bans unconscionable, that doesn't mean every state will. In fact, it's kind of a split state by state. Some of them are saying it's unconscionable and some don't. So even on our best day, what mandatory arbitration is doing is shrinking the field of where private firms like our firm can enforce the law. So with that,
Andy, let me see if I can focus a little bit, because you opened this whole arbitration can of worms, and I want to talk about it because it's critically important. But I want to focus specifically on the question is, for the individual plaintiff, can he or she get a fair shake in arbitration? And what about this issue that Mr. Doran, it's been talked about by John Lewis, that the federal courts have some transparency for these issues of public interest? And is it a problem that they're being arbitrated? So the first question is fair shake, and is it a problem that they're being arbitrated and not subject to public scrutiny all the time?
Well, first of all, let's set the field differently a little bit, because I think you have to distinguish between these cases. Payette was a case dealing with a labor agreement negotiated between parties who had bargaining power, which decided in Payette that they would give the arbitrator the full power to decide under any of the applicable civil rights laws, all remedies and what have you. And in fact, the union in that case had a conflict of interest, because the union didn't believe the individual had been discriminated against and indicated that it would provide that individual an attorney to represent that individual in arbitration. But Payette, to me, by the way, is a very limited case. Payette's limited in two factors. One is that you would have to have a grievance and arbitration clause which actually has those full powers, that the arbitrator has been given those full powers. Most collective bargaining agreements do not have that. Most collective bargaining agreements have a general non-discrimination clause and have a general arbitration clause. They do not specifically reference. So the first question is, I haven't seen a great rush since Payette that people are negotiating now all of these clauses to bring them into sort of conformance. And the Supreme Court had an earlier case called Wright v. Universal, which suggested that without that, you wouldn't get the Payette effect, essentially, which came down the line. The second question is the unanswered question that Payette had that lower courts are resolving right now, but the Supreme Court will again have to deal with. And that's the issue, is what happens if the union does not take the individual's case to arbitration? Is that an actual substantive waiver of that individual's rights that means that the individual then can bring the lawsuit into federal court? The lower courts, since Payette, have generally held that is a substantive waiver and means that the individual can, in fact, bring those cases into court. The Supreme Court's decision actually suggests otherwise. The Supreme Court's decision, at least Justice Thomas's view, is that the duty of fair representation offers that individual an opportunity to challenge the union when so. All of those are open issues. So I don't think we have seen clearly at all the definition. As to the fairness of the process, arbitration, in my view, is a fair process. I've practiced 41 years. I've been involved in negotiating massive, numbers and numbers of arbitration agreements. The process can be fair. It doesn't deal with all the issues that we're talking about here. Doesn't mean it's an unfair process. Doesn't mean that it's transparent in the way. Doesn't mean that individuals get justice. And let me make a suggestion to a program, because obviously I'm the employer on this side, or the employer representative on this side, of one thing that I think is important. Not everyone's case gets brought to court. Not everyone finds a lawyer willing to take his or her case into court. One of the benefits of arbitration, particularly under a collective bargaining agreement, in particular under a collective bargaining agreement, is that those individuals, particularly, let's just take Payette, low-wage earners, janitors, working in buildings, that individual's age case might not have been an age case that any plaintiff lawyer might have taken, okay? Might not have had the worth, the weight of the case, the issues of the case to deal with. Arbitration offered a vehicle to have that case heard. Arbitration offers a vehicle to have other cases heard. So in my view, the issue is not the unfairness of the process. I talked at the National Academy of Arbitrators this year as a keynote speaker, where I criticized the National Academy of probably not having enough arbitrators, if Payette was actually going to be extended, who had the competency maybe to even deal with all of the different issues. Because when I started practicing, we didn't have all of the laws or regulations that we now have, all of which require a greater specificity in terms of application. So therefore, the arbitration world needs to, if it gets more refined, needs to wake up to that, because those are big issues that are going to confront us, whether it's disability claims or other types of claims. But I do believe it's a fair process. If that's the fundamental question, it can be a fair process. It's not necessarily a full substitute process, but it can be a fair process.
Okay, and just so we're clear, there's really sort of two lines. There's the arbitration agreements contained in labor contracts, right?
And then there's a Circuit City line, which are individual contracts of when someone's hired or working for a company. The company says, if you have these type of employment disputes, they get heard by an arbitrator. And by the way, let me talk about Concepcion for a minute, because I believe actually there's a good chance the consumer wins in that case because of federalism principles. I think there are a number of conservatives on the court, as evidenced by Tuesday's argument, who are concerned that they would be trampling on us how a state views unconscionability. As Ruben said, there's about 20 states, I think, currently that adopt an unconscionability standard. But the point is I think they could easily win. I have found that not all clients that I represent have gone to arbitration as the means to deal with this process. Arbitration, in certain cases, has been viewed as being a way to have expeditious resolution. By others, it's been viewed that it would rather have litigation in the courts or be willing to subject themselves to potential litigation in the courts and not go to arbitration. So the idea that the employer community is sort of bound one way or another is really not the case, You'll find wide variances even with respect to arbitration practices. This is what's covered. So to me, and you had raised with me before the issue of transparency. I'm not as concerned, I guess, as other members of the panel might be on the issue of transparency in this regard. I believe that if employers, in fact, engage in discriminatory work practices, that those practices will come out. The fact that you have cases going to arbitration means maybe in a particular case those facts didn't come out. It doesn't mean that the issues don't come out. It doesn't mean that various agencies might not have the issues or that there are other ways that those issues surface. So I don't think that's an argument against arbitration just because there is not the same transparency as in federal court.
Well, let me throw one at you a little bit here because you know something about the Ledbetter case. Ledbetter came down and it was a statute of limitations case, and the Supreme Court ruled for the plaintiff, and it was a paycheck case. The question was whether the statute of limitations ran from the last discriminatory paycheck or did it run from the time the company implemented the wrongful course of conduct, as I recall. Would you agree with me that if the Supreme Court didn't publish an opinion that was open to the public review, that Congress wouldn't have known about it and issued corrective legislation?
Well, it might not have known, and one of my partners argued on behalf of Goodyear in that case. And
that's why I said that.
They might not have known about Lilly Ledbetter. I don't know if they would have. I doubt very seriously they wouldn't have known that there could be actually statute of limitation problems with respect to that type of issue. The case itself, look, I've been involved twice in that type of situation. One was the Betts case dealing with the Age Discrimination Act, which led to the passage of the Older Worker Benefit Protection Act, where the Supreme Court ruled a certain way in Safe Harbor and Betts, and then the Congress reversed that result in the Older Worker Benefit Protection Act. Having said that, the fact of the matter is I have serious questions that those issues would just remain under the table or hidden, and that Congress would never find them just because that particular case would have been heard by an arbitrator versus the Supreme Court, or that opinion would not be published. So to me, that is not really, I mean, I hear you, but I don't know why that's the problem. I could see other issues with respect to arbitration, but the transparency issue is not one to me that would mean that employers could have egregious conduct totally hidden from view and remain hidden from view because of the fact that they have arbitration. I've seen employers who have arbitration and have had their employment practices nonetheless scrutinized and publicized, even though they have arbitration practices.
I want to come to Pat and Bob, but first I want to ask Leslie a question. Employee goes to work for an employer, and he signs an agreement of employment, and whether it's in small print or big print, it says if you have a dispute, it's going to be subject to arbitration. And I gather Andy says, this could be a good thing because maybe there's an expeditious way to resolve a dispute without hiring expensive, high-priced lawyers like you guys. What's wrong with that?
Well, you know, I'm going to come at this from the notion of the judicial selection process, and I would say to you that what's wrong with that is that, and I'm not up to speed on how arbitrators are selected. I know that there's going back and forth, and you pick people off a list and so forth, but I would say to you that the beauty of having an Article III judge listen to that claim is that that judge was selected in a purely participatory process. And by that, I mean that a president who has been selected by the people nominates the Article III judge, and a Congress who has been elected by the people confirms that judge. So individual citizens have a democratic ability to determine who it is who's going to hear their employment discrimination claims. And, you know, back to John Doerr's point last night, and I'm really sorry I missed his remarks, but, you know, if he was talking about the power of the federal courts to address discrimination, nobody knows that as well as we at the Legal Defense Fund. And for, you know, 7 decades, we have worked to bring discrimination cases in mostly federal courts. And for about 4 of those decades, we have also taken a big, large, great interest in seeing who gets on those courts, because we understand that the composition of the judiciary is the ultimate determiner of how those cases get decided. And I understand you have a wonderful panel later on with Judges Clement and Judge Nixon who are going to talk about diversity. But I also would say here that what's also important is to get diversity of background so that you don't get all defense lawyers on the federal courts, that you have some representation from plaintiffs' lawyers, so that person who does not go to arbitration and gets into federal court knows that he or she has a fair shot when they file their claim.
Bob and Pat, I know that you all are thinking about this Pyatt decision because it puts your clients on the front lines in terms of whether they're going to be responsible. Possibly, Andy says maybe not, for arbitrating some of these cases.
Perhaps, but the dissent in Pyatt said that the majority opinion may have little effect, and I think that may be the case, because from what the key holding from the union standpoint is that these mandatory clauses are deemed mandatory subjects of bargaining, which means that the union has an obligation to bargain if the employer raises the issue. But it does not mean that once impasse is reached in bargaining, that the employer will have the opportunity to unilaterally implement those clauses. It would take the union's agreement to do so. Absent that, there could be no clear and unmistakable waiver. So I think with that key holding, we're not finding employers who are trying to cram these clauses down the throats of the union. I did just an informal survey among probably the 7 or 8 largest national unions that regularly arbitrate cases. And even though when Pyatt was first decided, there was a little panic at that point, right now, virtually nothing is happening. We're not finding employers, we're not finding Andy's clients insisting, and for their own self-interest in many regards, not insisting on bringing Pyatt mandatory clauses to the table. Because I think they know, even if they do, they're going to have to create maybe a parallel system to arbitrate. And it's going to take the union's agreement to do so. And just from an historical perspective, and Andy will agree with this, the creation of arbitration as a means of rapidly resolving industrial disputes is one that was created out of informality. Lawyers generally are not involved in that process. There are some unions that regularly use lawyers, but there are also some unions that ban lawyers from arbitrating cases, and there are other unions that have policies against utilizing lawyers, and that's because of the expense involved. And the system of arbitration, while I'd agree with Andy that it is generally fair, has very lax rules of evidence, which makes it fairer as far as a lay staff representative presenting a case. And by the way, I do want to say this, since we're at a law school, I will say to you that probably a well-seasoned staff representative of a union is head and shoulders above a typical lawyer in presenting a case in arbitration. And that doesn't even go to the question of whether or not a staff representative can present a complex Title VII case. So I think we've found so far that Payette is having little effect, and that employers are not demanding, and unions are certainly not agreeing to the mandatory arbitration clauses that was contemplated in Payette.
Pat, what's your take on this?
Well, I'll agree with a few things that have been said. First of all, I'll tell you, this whole morning for me is an eye-opener. It's a real recommendation for continuing legal education, because a lot of the things I learned in law school about pleading standards and summary judgment and how you make a case, these Supreme Court decisions just go back on 180 degrees. So it says to me, if you're from a state that doesn't have continuing legal education, you don't find out about this, your client's going to be in trouble. But the second thing is that I did a lot of arbitration after I was with the government for a couple of years, and I was in private practice out in Northern California, and before some marvelous arbitrators. And my opinion about arbitration is that if you had a good arbitrator and you had two representatives who truly wanted to resolve their dispute, it was a wonderful way to resolve that dispute. The flexibility was immense. The arbitrator could decide which issues were really in dispute and take evidence on those issues. The parties could decide on stipulating to facts that weren't in dispute. You didn't have to spend time litigating those things that were not in dispute. And you really could get down to, as Sam Cagle, a well-known arbitrator in the San Francisco Bay Area, used to have. He had a little sampler up behind the chair he used to sit at the end of the table. It said, let's get down to the nut cutting. And you could get down to the nut cutting pretty quickly, in Sam's opinion. In fact, most of the time after the two counsel had made their opening statements, Sam would call you back into the back room, and he'd say, well, this is the way I see it, and you know, maybe your evidence is going to persuade me otherwise, but maybe the two of you ought to go out in the hall and see if you can resolve this so that I don't have to hear the evidence that I think I'm going to hear. But at any rate, there are problems with arbitration. There's limited discovery. There are generally lax standards of evidence. Sometimes, and there are other kinds of questions about the expertise of everybody in able to present the case. So but I think generally arbitration is in its place, and as I think Cyrus said, between parties of equal bargaining power, a good way to resolve a dispute if in fact people are interested in doing it. But the overall context in which we're talking about this problem is that sometimes the parties really aren't equally interested in resolving the dispute that's before them on the merits. And what's happening here is that one party or the other, or both, are using whatever means they can in terms of tactics or strategy to try to get an edge on what's happening. And unless you've got somebody who is in control of the process of the lawsuit and who has authority to control those tactics and strategies, a lot of times they're going to take over the substantive resolution of the lawsuit. And I think we talked a little bit, the first panel talked a lot about whether or not the cases they were describing were really pleading cases or whether there was something else at issue. And that's really the same sort of situation that's at issue here. What is the access to a legitimate means for resolving the dispute? It can be, in certain cases, arbitration. In other cases, it may be the federal courts or state courts. But there are even in federal courts problems with judges who aren't interested or not willing to control the discovery in cases, and that gets out of hand as a strategy or tactic.
I want to throw something to my two experts on arbitration in the labor context. When you represent a labor union and you're arbitrating or negotiating a contract, your obligation is to
The union.
the group, right? The
Right.
collective unit, okay? And when you are litigating an employment discrimination case, Cyrus, your obligation is to the client.
To our client,
To
and
client.
if it's a class case, also to the absent class members.
Okay. Does it present a conflict if you have a Pyatt situation, okay, and the union is required to arbitrate this claim, but maybe it's not in the interest of the collective unit because maybe the employer says, if I pay the damages under this claim, the company's going to go out of business, right? And there may only be enough money to pay this person, but not the rest of the workers. I mean, doesn't that present an inherent conflict of interest? Possibly.
Well, let's not go inherent, but yes, that's a problem. But I think you got to understand that labor arbitration is just one more step in the collective bargaining process between the parties. There's an ongoing relationship there between these parties. And the union is going to handle a lot of individual cases, and again, it depends on the case you're talking about. The union is handling a lot of individual cases where the conflict is much less of a problem than if it were to handle a very complex Title VII case that would, as you say, maybe threaten the company and the jobs for which the union has employees that they represent. So I don't think there's an inherent conflict, and I think there's nothing, by the way, in Pyatt that suggests, even if you don't have mandatory arbitration clauses, that says the union is prohibited somehow from handling Title VII cases. It just means there may be another bite at the apple to enforce statutory rights. And I think that's the problem that the employer has with Andy Kramer. I mean, I've handled arbitration cases, typical discharge cases. A just cause is actually a much easier standard to prove and win on, mainly because the burden there in a just cause for discipline is on the employer. I'm not too sure if it was a discharge because of race that the arbitrator would say the same thing, or they may go to a burden shifting type of discussion. But no, I think it depends upon the case for the most part. The union's not prohibited from handling race cases or age cases or any prohibited conduct cases, and can do so. It's just that there should be statutory rights still available to the plaintiff in most cases.
I heard a little bit from Andy say something to the effect that, maybe this is a quicker way to get a remedy because the court system may be slow. Leslie, what's happening with the federal judiciary? How many openings are there? Are we filling them? Is there a backlog? Tell us a little bit about that.
Well, this is a great opportunity to talk about kind of judicial nominations as an access issue, access to justice issue. And that's because the vacancy crisis right now in the federal courts is at a all-time high. We have over 100 vacancies around the country in federal seats, and we only have about 850 lower court appointments, both district court and appellate court. So what this means is that 1 in 8 seats is vacant. And for you law students out in the audience, I'm sorry about that because that means fewer judges to apply to clerkships. And let me just say, I can't be at a law school and not say this, that to encourage you to apply to our summer internship program, naacpldf.org, both in Washington and New York. I'm sorry for the advertisement, but we want geographic diversity from the South as well, and so I wanted to throw that out there. But let me talk about this vacancy crisis, because it really does have an impact, as I'm sure all these litigators up here know, in that, if you file a case and you've got an individual Title VII claim, and I have represented workers who are still working at the company that they have just sued in federal court, it is tremendously difficult to be in that situation. And when you have fewer judges trying your cases, and their caseload is a lot higher, and they are not moving their cases as quickly, you could be working for a company that you are also suing for about 2 years until your case gets resolved. That's just one example of the cost it's having, I think, on litigants. And, I looked at the Georgia numbers before I came down here, and you guys down here are example A in terms of what is going on with this vacancy crisis, because you have 11 federal court seats in the Northern District. 4 of them are vacant. So the lawyers who practice in Atlanta have got to be seeing this firsthand, what impact it's having on how swiftly justice is coming down from the Northern District of Georgia. And one of those district court seats is considered a judicial emergency, and that means that based on the caseload of the Northern District, that they really need a judge. And there's also a judicial emergency in the 11th Circuit, because Judge Birch has recently stepped down, and so we need to fill that seat very quickly. But let me tell you why there are so many vacancies, and then I can let the other panelists perhaps talk about this. The situation in Washington is that the confirmations are not coming very quickly out of the Senate. And there is obstructionism going on in the Senate. It is at an all-time high, and we are just about to close the first 2 years of the Obama term in terms of judicial nominations. And he has been able to confirm only 41 judges, only 10 circuit court judges, and 31 district court judges. That is the lowest number of any first 2 years of a presidential term since FDR. That's how bad the situation is. And to give you a recent comparison, in the first 2 years of the Bush administration, 2000, 2002, when you had a Senate of a different political party, and you'd think there'd be more obstruction rather than less, 100 federal judges were confirmed. So Bush, 100 federal judges, Obama, 41. And what that means is that we're getting more and more vacancies as more judges are retiring, and we're not filling them up. So, if I could do anything in coming here today, it's to urge you to contact your representatives, your senators especially, and just talk to them about the vacancy crisis. We don't even have to get into the politics of judicial nominations and questions about ideology and so forth. This is a good government issue, and our federal judiciary isn't getting staff to do its job.
Well, it's interesting you brought that up, because Mr. Doar mentioned last night that he was able to get a judge to hear his case at 11 o'clock at night, and I was just surprised. I'm not sure that I've had that experience. But I guess we're in different times. Andy, do you see things the same way? I mean, from the employer's perspective, are you concerned about it?
Yes, and it's not helpful for us either. This is not something that divides the bar, in my view. This is a common goal where the issue of appointments generally, and it's also in agencies, it's not just with respect to judicial, where it doesn't help. Forget what persuasion you're talking about. You want people to be able to staff. You want things to get resolved. If it doesn't get resolved, it's just going to sit there and fester. Or you have extremely long delays, as we have in some cases now, because the judges just don't have time in the docket, what have you, to deal with it. So it is a problem on the employer side as well. And I want to go back to my point that I was making. Arbitration isn't viewed on the employer side 100% as the absolute panacea, and it shouldn't be viewed that way. There are some employers who view arbitration in a certain manner and think it is positive. There are a lot of others who even started down the arbitration road and moved away from it. So the fact of the matter is, but then we're back now to the judiciary where some of them are re-looking at it, actually, because of the fact is the delay matter that they have in courts. The big battle we have with respect to the issue of arbitration, it was interesting, the first panel, is not the pleading issue, because we can agree on the pleading issue, is the discovery issues. And we get involved in the discovery issues, which is a more complex issue for us than the other side on the pleading issue.
And I know, Pat, that you've been involved in the judicial selection issue. What's your take on it? And Bob, of course, I know you think about this as well.
Well, I have to agree, and when you look at what happens in the Senate on these appointments, there are these secret holds that are done on different candidates. There are threats of filibuster that's done by the minority party in the Senate. And then if finally the nomination of a judge does get scheduled to come to the floor, usually there's a little bit of discussion. They move to a vote, and the judge is approved 97-2 or something like that. So you wonder where this threat of filibuster came from and why it was made. Well, you don't really wonder. We're not that stupid. We know that what's up there is it's just an outright refusal to approve the nominees of this president, and there's no good reason for it. Let these things come to the floor. Let the senators debate them. Let them vote on it. Let's not do it through secret holds and threats of filibusters.
Before we move on to the next issue, which is class actions, I want to give Cyrus the last word on the arbitration issue. I know this has been an issue of passion for you, that there shouldn't be compulsory arbitration, and you've had success in the courts. And in part, I read about your cases, and I guess you would say that I wouldn't be reading about your cases if they were arbitrated, but I'd allow you to speak for yourself.
Well, we talked a lot about transparency, so I'll move to another part of it, which is that the principles behind mandatory arbitration is that there's consent. I really wonder, is there true consent in a contract of adhesion? First-year law students, you know what that is. But when there's no ability to negotiate, I mean, how many people in this room have bought a cell phone and went and said to AT&T or some other company, "Oh, can you change this paragraph?" They're not going to change that paragraph. How many people have gone to apply for a job, and then this little tiny fine print that you can barely read, you've given up your right to go to court, that you're going to say, no, I'm not going to apply for that job, I'm going to cross that paragraph out and then send in my application. So there really isn't consent. And that's where the discussion about the labor situation is different, because there is a more of a level playing field in negotiation. They can talk about the terms of the collective bargaining agreement, but the average consumer, the average employee is not in a position to negotiate, and therefore there's really no consent.
I want to move on to the issue of class actions, because you opened the door this morning. I admittedly read for the first time Josh's amicus brief for the NAACP before the Supreme Court in the AT&T case, which was argued this week. And quoting from Josh's brief, he says, "Civil rights and class actions have a historic partnership." And then he goes on and he says, "Class actions offer remedies for civil rights violations in circumstances where individuals are unlikely to proceed on their own because they lack timely notice, have insufficient resources, or fear retaliation." Andy Kramer, what do you think about that?
Well, I think one thing that's important, because first of all, in the labor context, you have to take these cases out, and one of the interesting things actually about AT&T and unconscionability is that it wasn't unconscionable to the actual contracting party. And I totally understand as whether it's a contract of adhesion, but their procedure for paying claims was generally to guarantee the claim gets paid. The problem is the unknown, the groups that wouldn't be brought to bear, which the state feels is unconscionable to deal with and not to have. To me, on the employment side, with respect to the whole issue of class actions, from an arbitration perspective, if you have class actions in an arbitration and allow an arbitration, you're probably not going to see many companies candidly go to arbitration with respect to class actions. The AAA rules with respect to arbitration of class cases is about comparable to what we'd have in Rule 23. Most of the major arbitration services going to where we get arbitrators and selection process and the rules governing that would govern it. So if, in fact, AT&T gets decided that way, I think you'll see a number of companies potentially change what their view is, because the fact is that the issue that they have is having those cases heard in an arbitration setting will be removed from an expeditious point of view, from even a document and discovery point of view, because of the rules of procedure that most of them are following. So I think you're going to see, if that decision goes that way, that at least, not in all states maybe, but in a number of states, a change of employer policy. Because the view of the employer then of getting an expeditious resolution for the particular individual, that will then not be the same if it's going to be a class case dealing with class issues.
Let me just focus specifically on the sentences that Josh had in his brief.
Right.
This question of the partnership between class actions and civil rights cases. Right? Is it a fair statement, Cyrus Mary, Leslie Prohl, that it is harder now than it ever was to certify a race or gender discrimination class action?
Absolutely. Well, first of all, in terms of the partnership, the class action rule in the federal rules is called Rule 23. If you read the advisory notes, it says this is a particularly important rule for civil rights cases. It's always historically been that class actions are the way to bring about change in the civil rights context. If you actually look at how many classes have been certified in an employment case in the last 5 or 6 years against a corporate defendant, you can count it on one hand or less. I mean, you have Walmart, which is, maybe go up to the Supreme Court. There's a couple of others. There's very, very few. There actually have, other than Walmart, it's hard to think of a major comprehensive case of that magnitude where the class has been certified. So it's a tremendous uphill struggle. And we've had highly meritorious cases where both sides' experts have found evidence of discrimination, and judges are having a hard time getting their minds around certifying the class. So we're in a hostile environment in terms of getting a class certified. There are different ways that the issues have come up. I mean, one of the harder things is that in today's day and age, in terms of battling discrimination in the workplace, is that it's very subtle. There are not that many cases, although there are some, where there'll be nooses in the workplace or really overt racist kind of acts. But more, we're dealing with subtle discrimination that takes place where there's kind of a headwind created against women or minorities in the way, let's say, performance evaluations are carried out, or the way jobs are not posted. There's not a level playing field to compete for jobs. So these more subtle kinds of claims, the issue of disparate impact, which is taking facially neutral policies that have an adverse impact, is very well established in the Supreme Court, and there's a high degree of resistance to it in the lower courts when you try to look at that from a class action point of view. So that's the kind of issues that we've been struggling with.
Let me ask you a question. Why doesn't somebody just bring a case on their own, their own behalf, for their own personal interest, for their own loss? I mean, what is the value, if you can explain it to everybody, of seeking redress on a class-wide basis versus an individual basis in terms of cost, economy, and whatever? Well,
the heroes and heroines have come to our office, including Barry Ellen, who you'll hear later today. They're coming to us not because they're trying to vindicate themselves per se. They're trying to open the door for those that follow behind them. They're trying to create that level playing field, not only on behalf of themselves, but all others. And one of the great satisfying things when you have a great settlement like Texaco and Coke and these other cases is that Barry Ellen brought that case on behalf of African-American employees. Within a couple of years, we had white employees calling us, thanking us about that case. Why? Because when you have more transparency, more of a level playing field, processes that are more fair, it's good for everybody. But if your goal is to change a company's behavior for the good, the only tool you realistically have is a class action tool that you won't be able to do it one individual against a company.
And let me just say, I think kind of even taking it up a step, I mean, we have desegregated the major social institutions, in our society over the years through the use of class actions and nothing else. And since keep talking about Josh's brief, there's a very interesting footnote talking about how Brown was a class action, and it was intended, and it had to be that way, because if it had been an individual case, no court would have treated the remedy as an order to desegregate. It would have been the admission of one student. And you look at all the desegregation cases that we have brought over the years, it has not been one student at a time. If it had been, we'd still be, way back in terms of an integrated educational system. But some of these institutions, schools, it had to be that way. In housing, it started out that way, certainly. And in the workforce, you just would not have the diversification of the workforce had you been relying on these individual cases, especially when we're talking about managerial jobs and so forth. It just wouldn't have happened.
So if I hear you right, to quote, I guess, an earlier panelist, maybe John Bale, the failure or the inability to certify these cases having a disparate impact on the enforcement of the law. Am I characterizing this correctly?
Absolutely. And we will, if discrimination is persisting, which it is, and we are retreating in terms of our numbers, we will be resegregating, and that is just what's going on in the school systems. There's a lot of documentation about that, and so we need to continue to look at things on a class basis in order to maintain the changes we've accomplished.
Now, Andy, I know there's a whole other side to this class action issue, because I've never met a defendant who said, I'm happy to have the class certified unless they've got 25,000 individual suits they want to resolve at once. What's your perspective?
Well, the real issue on the employer side is that class actions, well, first of all, the employment arena is in some ways, in some cases, I'll be the first to admit, a good place for a class action. In other cases, it's not, because of the differences that you find in the employment arena and employment practices. So the first reason that you have is that in terms of the class, I mean, the big reason for employers is that most cases look at a liability issue. I mean, it's, if let's just put it right on the table, because it isn't an issue of where it is. It's a question of the number of people who are involved in the potential scope of relief. So you immediately change the calculus in a class, assuming it's certified. So if you have a certified class, a lot of those cases ended up getting settled, not litigated, because of the fact of the matter is, in a certified class, and where because the employer or the employer sees it might get certified, okay, the employer then is looking at a whole different issue as distinct from 1, 2, or 3 employees and dealing with the practices. Number 2, going to the question about scope of relief. Your relief then is going to be much broader. Your relief is going to cover a whole bunch of employment practices that another would be. So for an employer, just from a self-interest point of view, is going to say, well, why am I going to invite that type of action? It's not going to generally invite that type of action. There's really no interest of the employer to do that. Now, that doesn't mean that the employer is a discriminatory employer. The employer can say, well, look, my view is I'm willing to have a procedure, okay, that allows employees to come, have their cases heard, have them decided, but we don't see the benefit to us, clearly, of having a class case in terms of it for the reasons that I've just expressed. Or the fact of the matter is, it leads to extensive discovery covering multitude of things where, again, the cost of settling is cheaper than the cost of litigating, potentially, at some point in time. So really, on a very frank and real basis, it's not based on the fact of arguments against all the things we're talking about of class action. It's the practicality of the matter and where you're perceiving it. And the perception isn't that, oh my goodness, this is a terrible way to go. In fact, I created this whole notion of using class action to get these VEBAs, these health trusts established in the auto and rubber industry, because we had to bind all these retirees. The way to do it was to bring an action and use 23B2 as the basis to be able to do the action. So I'm the first one to use a class action where I think it's in my interest to use a class action. So the fact of the matter is I'm just pointing out here that the reasons are much more practical reasons rather than arguing about the efficacy of what a class is. I clearly won't argue about what the impact a class can have and the impact it could have either on employment practices generally or on a wide group. That doesn't mean that the employer who's resisting that, though, ipso facto, wants to promote discrimination.
I mean,
that's all my point is. It doesn't mean, though, that the employer is going to lay down and say, okay, this is a wonderful thing to do because I'm going to invite all this discovery, I'm going to get in all this stuff, and so on and so forth, assuming, again, you could get it certified.
If I hear Cyrus correctly and Leslie correctly, they would say that courts are more reluctant now than ever to certify classes. Do you agree with that?
Yes, we find that the case, even though there's an opposite side of it. We're now finding a statute which, when I started practice a long time ago, was really a dormant statute, the Federal Labor Standards Act, that is now finding collective actions, which is a different form of a class, basically, collective actions to be the way to go these days. And we're seeing essentially these collective actions being brought either under state law or under the FLSA, where you have consents, which have served the purpose of essentially a class for purposes of the things that I've just been talking about in terms of employer policies. So the answer is yes. We see the same thing on the certification issue, but we've seen a marked increase over the last 5 years of what I call these collective actions, which are in essence class-type cases dealing with misclassification, a whole series of issues under the Fair Labor Standards Act or state laws.
Before I turn it over to Bob and Pat, do you think the courts have leaned too far against certifying classes? Do you think that Cyrus has some validity to his argument or point?
I think some courts have. Again, you're talking about courts. There are lots of courts in lots of districts.
He's not going to admit that.
I'm not going to say that all these courts have misapplied it, but I know cases that we've been involved in where courts have actually denied certification. I think it was an appropriate result.
I was going to say that if we mark this part of the videotape confidential, would you give me a different answer?
Well, we'd have to turn the machine off.
Leslie, what's your take on why, is there an animosity, or, what's the reason that judges don't like these class cases?
Well, I think it's the kind of the same thing we're facing right now, just over a longer period of time, that have we come to a post-racial society that judges more than ever are, questioning really discrimination doesn't exist, or, it's too subtle to see. And you now admit somebody into the workplace. Why are you talking about terms and conditions? And, I think this is a great opportunity to bring up what I want to talk about is this recent 11th Circuit opinion that reversed a jury verdict in Gadsden, Alabama, where an African-American employee was called boy by his supervisor. And the plaintiff tried the case twice in Gadsden, Alabama. And each time, which is amazing to me since I used to practice in Alabama, got a jury verdict over $1 million. And the 11th Circuit recently reversed the decision, saying that the use of the word boy by the supervisor was not probative of race discrimination. And I want to commend to you a brief that we wrote on behalf of several civil rights icons, including one who's in the room, Judge Clement, all of whom knew Dr. Martin Luther King. And the brief goes through kind of the history of the derogatory and offensive use of boy in kind of the racial history of our country. And it talks about kind of there's no absolutely other outcome than seeing this as certainly even the most blatant form of discrimination, and therefore it should have been factored in, and the verdict should stand. And so, even when you get what we plaintiffs' lawyers call direct evidence like that, and you try your case and you get a predominantly white jury to, find that there was jury discrimination, look what happens, in post-trial motions. And so it's very difficult, back to your question, it's very difficult to get courts now, even on individual cases, and class actions. It's the same. It's that we don't want to be bothered with systemic change anymore.
I don't really know anybody on the employment side who have represented workers longer collectively, Pat, than you and Bob. Is it harder for workers to get a fair shake in court?
Sure it is, but I do want to make this one point. The class action as a tool that was certainly utilized in the 60s and 70s eliminated, for the most part, systemic discrimination in large manufacturing workplaces. And that was done by firms like that Judge Clement came from, Adams, Baker, and Clement. And they attacked various seniority systems that were in existence solely to discriminate against blacks. Now, the union's role in that was always a necessary party. Now, the union may have looked at being named as a defendant and irritant, but that's about all, because I think for the most part, the union in those cases had the same goals as the black plaintiffs, and that was to open up the seniority system, because any limitation on seniority as viewed in the context of a manufacturing plant was to bring in favoritism, and that's something that the union has always fought against. So I cannot imagine where we would be today without class actions, certainly in the South, in manufacturing plants, where those discriminatory seniority systems were then busted if they didn't have a class action tool.
Pat, anything?
Well, just the general idea that as a society, and the first panel addressed this, I think we have an obligation for a lot of different reasons, if not just the First Amendment, to have a method of resolving these disputes in a fair way. And that's a general question. Then you become a smaller question if it's an organized workplace where you have the union and an employer who have agreed upon a way of resolving the disputes, then that's probably a good way of doing it. Although I have to say that when arbitration was done, labor arbitration was done, it was really a substitute for the union's ability to strike, which during the contract period the union gave up in exchange for having the right to arbitrate its grievances. And most of that was not individual issues. They were class issues on behalf of the union with the employer over rates of pay, let's say, or other procedures or conditions in the workplace. I mean, to be sure, there was the just cause for discharge, the discipline case, which was essentially an individual case. But you had generally, initially, those two kinds of cases that went to labor arbitration. The ones between the union and the employer over the interpretation and the application of some provision of the contract, and the just cause for discharge case, which was an individual kind of situation. Most of these others grew up later on and sort of got shoehorned one way or another into that paradigm. But what you've got here is society trying to decide what is the most efficient way and just way of resolving these disputes. And in some cases, it's obviously an individual litigation that happens, or in order to really resolve the dispute, you need the class action or the global settlement. And you've got an obligation to provide that in a way that is fair and that doesn't give full play to the kinds of tactics and strategies that a lot of lawyers employ to try to avoid that decision, put off that decision, or make it difficult for the other party to get to a just decision of the case.
Ruben, let me just add one thing before we leave arbitration. The most surprising thing about Payette was that it was decided under the Federal Arbitration Act. Because the Federal Arbitration Act, when the Supreme Court made arbitration the kingpin of labor policy in '57 in Lincoln Mills, the majority relied on Section 301, which was passed in '47, to make labor agreements enforceable for the first time, like the FAA was meant to make arbitration agreements enforceable. But the FAA has a provision that basically excludes, except in the case of railroad men and some transport workers, collective bargaining agreements. And the Supreme Court in Payette relied on the FAA as the basis for jurisdiction. And that probably was the greatest surprise. And the other thing was it didn't decide, the Stolt-Nielsen question that wasn't decided was whether the FAA deals with a public policy exception with respect to and how public policy applies to do it. So those are things I think that are still going to be in the mix before we leave that don't necessarily affect other types of employment agreements other than AT&T will affect other type of employment agreements potentially, but deal with labor agreements. And because Justice Frankfurter dissented in Lincoln Mills on the grounds that the FAA clearly excluded employment contracts, and the Supreme Court made a wrong bet under Section 301.
Andy has a paper I think we printed, and I commend you to read it. It's terrific. If there's one or two questions, we'll take them. Anybody? Yes?
Then follow the procedure that came out of Savannah.
Okay, well, it's a terrific question. It was posed before. I'll summarize it quickly. Department of Energy operates the Savannah River Nuclear Facility where I guess they make bombs, or they used to make bombs. Now they're involved in cleanup. And their contractors, very large contractors, Bechtel, Westinghouse, DuPont, are required under the Department of Energy contracts not to discriminate. And the question is, they're using federal money, right? How do you make them not discriminate? And I hope that you stay for the final panel because we're going to be talking about remedies. And we're specifically with Michael Allen going to be talking about the Federal False Claims Act, which allows people like you who know that discrimination exists to bring a suit against the contractor, right, for violation of its obligations to the United States government. I hear you. I hear you. But we're going to talk about remedies later. Anybody else? Yes.
Well, in terms of up-and-coming lawyers, I think what this discussion hopefully shows is that we're going to have to be more creative. We're going to have to work harder. We're going to have to think of things that are non-traditional ways to try to bring justice to our, for our clients and to bring about change. Go ahead.
Just picking up on the points made by the prior panel, I mean, it makes discovery in employment discrimination cases and other discrimination cases that much more important because you don't usually have that direct evidence. Your client doesn't have a statement like that. And so you can't know that at the beginning. You have to go and prove your case circumstantially, so you really need all the resources and benefits of discovery right up until the time of trial.
But one of the lessons I've learned, and I just want to say quickly, is that the more time passes, the more things get front-loaded in the litigation. That's part of what Professor Malveaux was saying with her article. We almost have to start our cases now with the end game. We're going to have to start our cases saying, not only is this a potentially discriminatory practice, but we have a less discriminatory alternative. We have to be almost trial-ready at the start, do our best to be that way, and really use our experts to really explain how discrimination is working, not just that the causes what the more subtle forms are of that are causing discrimination, but there are less discriminatory alternatives. I think that's what we need to move ourselves to.
What bothers me is that there seems to be forgetfulness, that maybe the ability to remember what things were like in the 50s and the early 60s, which is now 40, 50 years ago, isn't around anymore. That people don't remember what things were like. I mean, it's like the old saying that the price of freedom is constant vigilance. And the fact of the matter is that to the extent people think this is a post-racial society, I don't know that it is. And certainly if people forget what things were like then, forget what had to be done at that point to change society, and stop understanding that, internalizing it, and appreciating it in what happens every day, and not just in their personal lives, but in the administrative lives of the court and the government, then we're going to turn the clock back, and we're going to turn the clock back in ways that are going to be much more difficult to remedy the second time around, because they won't be as overt. They'll be much more subtle than what they were before. And that's my problem, is I think that there's generally a 2 or 3 generation forgetfulness gap. And somehow we have to cure that, whether it's through education, whether it's through people speaking out constantly about it. But we have to do that, because otherwise we lose track of where we've come from and what we've accomplished. We forget that having accomplished it, we still have to continue to accomplish it every day. It's not done. It's not like a book that you can close. You have to keep at it every day.
On that note, the panelists will be around, and I hope that one of the things that comes out of this conference is people have an opportunity to informally meet with everybody and have a dialogue. The panelists will be around. I think to keep the trains running, my boss is telling me that lunch is ready, and then people should come back in here for the next panel, 12:30. Thank you all.